Good morning, everybody. Thanks for dialing in this morning. We have got a few people registered today, quite a few people. So we'll just wait a few more moments to allow everybody to join and then we'll start. So yeah, if you just want to make yourselves comfortable, we'll just give it 1 or 2 more minutes and then we'll get started. Okay, right, all right then. So I think pretty much everybody here is joined or joining. So good morning, everybody, and welcome to today's webinar on Japanese knotweed with CLS. My name is Faye Stenning and I'm the Marketing Manager here at InfoTrack. I'm delighted to be joined by Steve Johnson, Business Development Director at CLS, who'll be talking you through today's session. So just before we begin, I'd like to draw your attention, please, to the Q&A tab, which is located at the bottom of your screen. We will be running a question and answer session at the end of the webinar, so please type any questions that you might have for Steve, along with your name, into the Q&A box. That way, if we run out of time or your questions require further clarification, we can extract your information and follow up with you directly after the webinar. So I will hand you over to Steve now to begin today's webinar. Thank you, Steve.
Yeah, many thanks, Faye, and yeah, hello everyone. Welcome to this 45 minutes or so session on Japanese knotweed and property purchases. As Faye mentioned, do feel free to post any questions, and hopefully whoever it was that sent some questions into InfoTrack in advance, we will get to those both throughout and at the end of the session as well. So my thanks to you for submitting those. Thanks to InfoTrack for hosting and marketing this webinar. So we're going to be covering a few different topics today, all in the context of Japanese knotweed. Obviously, our section 1, we're going to be identifying what actually is Japanese knotweed, some of the visual clues you might need in order to identify it, the impact it can have on property, amenity, and some of the implications and responsibilities that arise as a result of Japanese knotweed either being found on property or next to it. And that will include some of the legislative tools that are available to governments and indeed citizens in order to get it treated and dealt with. We'll also look at the RICS latest position. You may well be aware that the RICS updated their guidance to their surveying community in February of this year, and that guidance became active on the 23rd of March, so relatively recently, or any minute now, sorry. We'll also look most importantly at the Law Society TA6 property information form. This obviously is the document through which the sellers can communicate to a prospective buyer the status of Japanese knotweed should it be located on the property. And there are implications for buyers, for sellers, and for their legal representatives, of course, in amongst the answers that a seller may give. We'll look at the CLS Japanese knotweed insurance and the terms and conditions that are available to yourselves and to your clients should you wish to take up the insurance. And then finally, we'll look at some outcomes to consider, some things that you as individual conveyancers and indeed as firm in relation to policy may wish to consider, and we'll cover questions that have come up throughout the session and those questions previously submitted. But we'll start with, what is Japanese knotweed? Well, the Victorian era was a time of excitement and exploration with the Industrial Revolution in full swing. And many of the things we still use today were born in that never-ending Victorian quest to make life easier for some. They brought us the bicycle, they brought us the electric kettle, photography, the electric light bulb, and a plant called Fallopeia japonica, a beautiful decorative garden plant that was also edible and could be harvested for cattle feed. Little did they know at the time that what they brought into the UK would later on become one of the most potentially destructive invasive species, causing quite a significant amount of concern to the UK property industry, either through physical damage or just the perception of blight that the plant can introduce. Now, when things go wrong, it's always good to have someone to blame, and this particular blame we can lay on the shoulders, arguably, of one Philip Franz Balthasar von Siebold. Quite apart from a spectacular name, he was also a pioneering German botanist who spent most of his working life studying Japanese flora and fauna. He achieved a great many things, but it was he, ladies and gentlemen, who introduced Japanese knotweed to Europe. It would appear that Japanese knotweed was part of a collection of live plants presented to Siebold by his Japanese hosts and transported back to Europe thereafter. Fallopeia japonica was particularly well received. It was initially housed in an and acclimatization garden in the Netherlands. Plant was a huge hit, even receiving, and for those of you who are keen gardeners, you may have come across this. I certainly hadn't before. The plant even received a gold medal from the Utrecht Society of Agriculture and Horticulture. But from there, the attractiveness and the robust nature of the plant led to popularity across Europe, and such was the Victorians' love of the plant that it featured in the Edinburgh Royal Botanical Gardens and was frequently the subject of artist drawings and paintings. But it was only once the plant was established in the UK that its destructive nature was realised. So what actually is knotweed? Well, it's a fast-growing plant native to East Asia. Ironically, Japan is one of the few countries for whom Japanese knotweed poses no problems whatsoever. In Japan, it competes with a variety of comparable plants, as well as being vulnerable to local pests, diseases, fungi, and invertebrates. And in fact, in some regions, it's seen as a positive, as it's a pioneer species and able to establish itself on lava by volcanic eruption, leading on to secondary foliation. However, in areas like the UK, first of all, we are not overburdened with volcanoes, but secondly, these balancing factors are not present and therefore it outcompetes all other plants very successfully and quickly by having a continuously growing root system called rhizomes, and we'll hear that term cropping up again throughout the presentation. And these rhizomes seek out nutrients and steal them from any other living plant nearby. Now, although the plant is invasive, it's not toxic and is in fact edible. It's been used to make bread, chutney, and also some alcoholic drinks. However, during the summer, spring and summer, it grows rapidly, up to 10 centimeters a day, and produces growths of up to 2 to 3 meters. And one of the things that make it quite difficult to identify, and this is reflected in the latest RICS guidance that we'll touch on a little bit later, is the fact that throughout the year it takes on very different appearances and even mimics being dead in the winter. So those of you who are keen gardeners may already be aware of the ins and outs of the look and feel of Japanese knotweed. For those of you who aren't, this is where you can get a feel for what you might be looking for at any particular time in the year. Now, the plant takes on quite different forms and appearances throughout its annual cycle, and this can make identifying it quite difficult. It can be mistaken for other plants such as bindweed or broadleaf dock, ground elder. Now, the photograph on the left shows the knotweed bud bursting through a tarmac driveway in early spring. And in spring, the buds resemble small, bright red growths, which will spring out from the crown of the plant. The growths take on the form of sort of reddish purple shoots, similar in appearance to asparagus. Now, as we go into summer, knotweed stems will grow into hollow reddish green stems with deep green leaves. Now, these are the stems that can shoot up to about 3 meters in height maximum. Now, you won't necessarily achieve 3 meters growth in the first season of growing. First season of growing, you may only get up to 2 to 3 feet, but left to mature over a number of years, they really top out at about 3 meters in height. With root systems, unfortunately, they go up to 3 meters deep and typically up to a maximum of about 7 meters from the originating plant. Now, as you get towards the depth of the summer, the knotweed will develop small creamy white flowers that cluster together alongside those brown green leaves. But after the summer, into the autumn and into the winter, the plant's foliage does die back, leaving brown brittle canes above ground, which over time will break down. They will decay completely, and what comes in the next year is fresh growth of new plant. But it's this changing cycle that acts as its defense, because particularly in the winter, it may well be that the plant is pretty much invisible to anything other than the trained eye. Now, part of the reason for timing this webinar, as we've done in March, is we're now at the start of the knotweed growing season. So those of you who are keen gardeners, now's the time to take a look and see if you have those little red shoots poking up above ground. It's any time around now that they'll start making their presence felt. Now, as you can imagine, there are a number of impacts of having Japanese knotweed in or within close proximity to your property. And these occurrences quite often find their way into the local media. They can be quite a controversial thing to have growing in properties or land that's neighbouring your land. It can lead to neighbourhood disputes, and we'll touch on one or two of those a little bit later on. And it's quite a visual thing. Once Japanese knotweed really takes hold, particularly if it's growing through concrete or through decking, as you can see on screen, it's something that you'll often see cropping up, as I say, in the local media. It can and does exploit existing weaknesses in properties. So you can periodically see Japanese knotweed growing through walls or foundations or fences. It's very adept at finding its way through the weak points in a construction. So paving slabs, the joints between them will often be a point of growth. And in addition to that, the rhizomes, the roots under the property, can travel unaffected for quite some distance. So a very small extractive root, which is carried on a boot or a car wheel or typically maybe a railway train. You often see knotweed growing alongside railway sidings, have been carried by rail trucks, can lead to its growth and propagation in areas where it wasn't previously present. Now you'll see on screen that there's a number of different cases that have made their way into the local media. The first one on the left here is Japanese knotweed property firm fined 18K over forest. Now this relates to action taken by Bristol City Council, acting on behalf of the owners of 7 neighbouring properties. The council took legal action against the owner, MB Estates, on whose property a sizable knotweed infestation was located, and they failed to act on the infestation despite being requested by the council, and were prosecuted and ultimately fined £18,000 by the local authority. This was actually the first Japanese knotweed prosecution carried out under ASBO legislation. We'll have a little bit more on that in a couple of slides' time. The case you can see on the right, unfortunately, somewhat speaks for itself, and you can see the poor lady there standing in her backyard, enclosed by a forest of knotweed. And obviously, unless that knotweed is fully treated, and an infestation of that size, one suspects would need to be dug out, she will be unable to sell or to remortgage her property. Now, when it comes to the treatment of, containment of, and potentially the prosecution of issues associated with knotweed, there are 3 main acts that control the spread of the plant. Now, it's worth noting that there is no statutory requirement to remove or to treat Japanese knotweed, but it is the property owner's responsibility to ensure that the outbreak does not spread. So it is not illegal to have Japanese knotweed on your property, and it is not a requirement that you treat it, but you open yourselves up to issues if the lack of treatment leads to the knotweed having an adverse effect on, for example, a neighbouring property. And part of the consideration is actually what could be considered to be an adverse effect. Firstly, on the left, we have the Wildlife and Countryside Act of 1981. And this sets specific guidance for the spread of non-native species that have caused problems within the UK, its environment or its infrastructure. And it is an offence to cause Japanese knotweed to grow in the wild under the provisions made within Section 9 of the Act. Now, Section 14.2 of the Wildlife and Countryside Act states that if any person plants or otherwise causes to grow in the wild any plant which is included in Part 2 of Section 9, Part 2 of Section 9 being the section of the Act which lists the invasive species incorporated within the Act, and he or she shall be guilty of an offence, and anyone convicted of an offence under Section 14 of the Wildlife and Countryside Act may face a fine and or 6 months imprisonment in the event that they are found to be guilty of propagating knotweed into the wild. Now, both the Wildlife and Countryside Act and the Environmental Protection Act of 1990 control the disposal of Japanese knotweed. The EPA stipulates that Japanese knotweed can only be disposed of at landfills which are licensed to handle contaminated soil. The individual or organisation that's collected the knotweed is responsible for identifying a licensed landfill and transporting the knotweed to the licensed handler. Untreated knotweed is not regarded as hazardous waste, but material containing knotweed that's treated with certain herbicides could be. So again, were you to have knotweed on your property, were you to engage with a company who was going to treat it, remove it, dig it up, then they will be required to dispose of the knotweed in a way that complies with both the Environmental Protection Act, and if they've used hazardous chemicals in the treatment of the plant, also complies with the hazardous waste regulation. Now on the right, we can see a little icon indicating ASBOs. Now, when you first think of ASBOs, one doesn't think of you having those applying to Japanese knotweed. Now, they were first introduced actually into the fight against Japanese knotweed as a part of the reform of the Act, which first came into play in 2014. The reform extended the scope of ASBO legislation, allowing them to be issued against individuals and businesses that don't control Japanese knotweed when they could reasonably be expected to do so. And it was under this legislation, that case I mentioned on the previous slide, MB Estates, they were prosecuted after several attempts to get voluntary action. And there have been subsequent prosecutions of landowners where knotweed has impacted on neighbouring property. As ASBOs are typically restrictive by nature, an owner of a property issued with one will likely be required to stop the spread of Japanese knotweed. And this will typically be measures that they need to take to ensure this, including making reasonable attempts to eradicate the knotweed from the property and from the properties of those neighbouring sites that it has spread to. And we'll have a look in a short while about some of the treatment methodologies that are available for landowners, for the buyers or sellers that you're representing in the event that knotweed is found to be on the properties that you are working. Now, we've mentioned a few times that the rhizome system can expand up to 7 meters underground from the plant on the surface. And although this is a little bit of a Janet and John graphic, I think it then really informs the challenge that both uninformed homeowners and home buyers and indeed home sellers have when it comes to dealing with Japanese knotweed, but also the challenge that the surveying community has when acting on behalf, for example, of a lender and carrying out a valuation survey. It's very apparent that the plant can spread its influence quite a significant distance from the overground appearance of that plant, and of course that potentially leads it into neighbouring properties. Now, what came out in February 2022 was an update from the RICS to the way its members are required to think about Japanese knotweed. And this was an update to guidance that was first issued in 2012, which treated knotweed with a significant degree of severity and put, whether deliberately or inadvertently, quite a significant degree of responsibility onto surveyors for assessment of a risk, which in a lot of cases was felt to be not fully visible. So we have now this new publication, the RICS publication, Japanese Knotweed and Residential Property, which, as I mentioned, comes into effect on the 23rd of March, a day or so's time. And it sets out a new assessment criteria for surveyors to follow and comment that where Japanese knotweed is within property boundaries, the diminution of value is likely to be limited to the cost of remediation only. And this is quite a significant change because previously Japanese knotweed, to some extent, the default position was that alongside the cost of remediation, the treatment program that someone might employ to remove or limit the impact of Japanese knotweed, there was always a significant impact on the value of the property. And it's felt now amongst the surveying community that that is no longer the default position. Depending on the severity of the outbreak, that still remains potential, of course, but it's not the starting point for the surveying community. So as we can see on screen there, surveyors now have within their valuation guidance that diminution in property value may only be due to the remediation cost. And we'll touch on remediation costs when we get a few slides on. But in addition, surveyors are only expected to identify if the plant is clearly visible. Now, we've already mentioned that a significant amount of sort of concern associated with the plant comes from the fact that the root system extends some distance from the plant itself. No longer could it be reasonable that surveyors are expected to, ascertain that that sort of underground structure. But in addition, clearly visible means quite a broad range of things potentially. If the property is masked by other plants, if the surveying is taking place in the winter when the plant has died back, then it might be reasonable now to suggest the plant is no longer clearly visible, and therefore not something a surveyor could reasonably be expected to pick up. Not only that, but surveyors are no longer expected to carry out plant-by-plant checks. Once again, knotweed may exist within quite a significant amount of other growth. there's not that expectation that one will go sort of delving into the undergrowth to check if there's evidence of those canes or those broad green leaves. Now, not only that, there is a new assessment zone recorded within the guidance that the RIC has issued. So we are, as I've mentioned earlier, now asking surveyors to assess visible growth rather than the rhizome root zone. And it's now considered that knotweed is, or the impact of knotweed is now considered with regard to amenity space. There isn't this default position that the knotweed has an immediate concern for the full structure of the building. If the knotweed is located in an area where it's really just the open part of the garden, or maybe decking, or whatever the area might be, you then have a downgraded risk compared to whether the knotweed was very, very proximate to the building itself, whether it's the garage or some other sort of, or the actual house or block of flats. Now, another critical change for surveyors is when they are required to assess knotweed off-site. We've already seen from our previous graphic that knotweed can spread not just its root system, but in fact the plants itself into neighbouring gardens. Previously, surveyors were required to make an assessment up to 7 meters from the boundary of the property that they were surveying to establish whether or not knotweed was present. Now, there were limitations and caveats to that. It wasn't reasonable for them to be expected to go and trespass on a neighbouring property to carry out that up to 7 meter assessment, and nor is it now. They were required, however, to make the best use of both the property that they're surveying's land in order to look into neighbouring sites, but also to make good use of public space, neighbouring paths or whatever it might be, again, in order to assess for the presence or visible presence of knotweed. However, as you can see on screen there, the area that they, or the length of the distance from the property that they're now required to assess has come down from 7 to 3 meters. And as a result of all of these changes, they are changing the advice that they now give to lenders in order to be more measured on the severity of impact that knotweed growth may have ultimately on the value of a property. Now, the question remains, of course, is to what degree these changes then impact on the way that individual lenders treat knotweed, and indeed, of course, whether or not this guidance change brings in a change subsequently to documents such as the TA6 form. And that remains to be seen, but we'll be keeping a close eye on that. So in the meantime, then, we remain with the TA6 form as presently recorded. And I'm sure the document that you can see on screen there is one that's only too familiar. Since 2013, the seller has been required to state whether or not Japanese knotweed is present on their property through the TA6 form. The form has been revised, obviously, since 2013, and further guidance was added in February 2020 with the release of the 4th edition. And you can see, of course, that buyers have 3 possible answers: yes, no, or not known. And what we'll do over the course of the next slide or two is just to understand the implications for sellers and, of course, for legal representatives according to the answers that are given on the form. So let's take yes first. Well, yes could mean a number of things. Yes, knotweed is present on the sale property. Yes, knotweed has been present, but has either undergone or is undergoing a treatment plan. And if it's the latter, the plan could be in the treatment and monitoring phase, typically the first 3 to 5 years, or it could be in the post-treatment 10-year period where an insurance-backed guarantee is in place. Yes could also mean that the property itself is not known to have knotweed on it, but it is known to be present next door. And once again, it could be present at the moment or previously present with a treatment plan underway. But if the seller does answer yes, then they are required, of course, to complete part 2 of the question, which is to establish whether or not the nature of the knotweed infestation, whether it's present now or previously present, whether there was a treatment plan or an insurance-backed guarantee in place. And now you can start to get into very much what a buyer or indeed lender is prepared to accept. For example, if the knotweed is on the neighbouring property and it is in the process of being treated, what does that mean for the buyer of the neighbouring property or indeed their lender? It can be very much case by case, but generally speaking, we understand that the majority of lenders will still lend on a property if there is evidence that knotweed is undergoing a treatment plan, a treatment program with an insurance-backed guarantee. The question mark is actually what would they lend, at what value would they consider the property to be rated, particularly given the recent changes to the RACS guidance. Now, let's turn our attention then to know or not know. The guidance in the TA6 form is for sellers is that if they are unsure that the Japanese knotweed exists either above or below ground, or unsure whether it's been previously managed at the property, they should answer not know. The key here, of course, is just how difficult it is for homeowners to be certain that Japanese knotweed does not exist in the terms required by the form. To be certain, and therefore choose no, the seller must be absolutely certain that no knotweed is present both overground and underground. So there's no plants and not even a root. Bearing in mind the growing cycle, the dormancy, the depth of the roots, that's quite a challenge. And if that's not difficult enough, the guidance goes further presently, asking the seller to confirm that the plant does not exist within 3 meters of the property boundary, even if there are no visible signs above ground. So it's interesting that the RACS guidance has now come down for impact on neighbouring property, has come down from 7 to 3, and for them it's visible growth only. Whereas I don't believe that there is that distinction between visible growth and underground sort of extension of the property to the plant to a neighbouring property that allows for a seller making a declaration on this form. So really, in order to confidently answer no, the seller must be certain that no overground plant or root system exists within 3 meters of the property. Now, if you stop for a minute, picture what 3 meters or around 10 feet looks like either side of your property. Would you be confident enough if you were selling your property to answer no? And of course, what really happens as a result of this is that the majority of transactions, a sensible seller, frankly, would answer not known, and in doing so, pass the liability for any Japanese knotweed across to that subsequently turns out to be present across to the new owner. Of course, they can only do so if they genuinely don't know. If there is known to be knotweed, then of course answering anything other than yes introduces quite a legal exposure for the seller. Now, in terms of eradication, we actually have to use new terminology. If the previous versions of the TA6 form made mention of the word eradication, Japanese knotweed, and it's apparent that other than through complete removal of the underlying soil within which the knotweed is growing, eradication is actually somewhat difficult. And we really now have seen a change in terminology amongst treatment providers and indeed and from the TA6 form itself towards the word mitigation. Really, Japanese knotweed for the majority of residential transactions will be, people will seek to mitigate its growth rather than eradicate it completely. There's a variety of different techniques that can be used, many of which some of you may have come across Japanese knotweed in the past, may have had some personal experience of it. There's a whole wealth of organizations out there that will offer Japanese treatment programs as one form or another. To remove Japanese knotweed can be a costly and lengthy process, and as I say, involve the use of these professional firms. And they will employ one of 3 methodologies. The quickest, by far the most costly method of removing Japanese knotweed is to excavate the plant, its roots, and any potentially contaminated soil and take the waste to a licensed landfill. By contaminated, what I mean is there is the presence of a rhizome from which the plant could subsequently grow. And as I say, these rhizomes can stay dormant for quite some period of time, and simply through disturbing them can prompt them into growth. So full excavation typically takes 1 to 2 weeks, but subsequent to that, when the land is filled back in, then one is free to really act on the land as one wants, whether you're building further sheds, outbuildings, decking, whatever it might be. The land has been now remediated, and typically with treatment firms will have a guarantee associated with that remediation. But where you have outbreaks on residential properties, in reality, the majority of treatment programs will be one of the 2 following methods. Foliar spray is where herbicides are applied to the top and the underside of the leaf, and this is absorbed and carried into the plant. Repeat applications of herbicide over the course of typically a 2 or 3 year program cause the plant to become stunted and reduces its capacity to photosynthesize and therefore regenerate. And you can expect over the course of 3 years, the plant should die back completely. Stem injection process is usually used where smaller concentrations of Japanese knotweed are found, and this involves actually injecting a dose of undiluted herbicide directly into the stems of the plant. The benefits are that it can be done in all weathers because the rain doesn't wash off of the leaves the spray that was previously deployed onto them. And it reduces the impact of potentially damaging non-target plants. Spray can be potentially a little bit indiscriminate, but obviously if one is injecting herbicide directly into the stems of the target plant, you could do so without affecting neighboring plants. It's also more effective in situations where nearby trees, for example, have a preservation. Now, both of these treatments are far cheaper than excavation, but they take place over a longer time frame. A typical residential outbreak might cost somewhere between £3,000 to £5,000 to treat over a 5-year period, which normally consists of 3 years of treatment, i.e. the deployment of the foliar spray or the injection of herbicide, followed by 2 years of monitoring to ensure there is no regrowth. Now, during that period, the treated area typically, and it's down to the conditions of the treatment companies, typically must stay undisturbed. So you can mow the lawn, but you can't carry out any landscaping work, for example. Most treatment companies accept staged payments, except where the property is up for sale. Now, in these instances, they generally ask for payment of the entire project cost up front. And indeed, the vast majority of lenders would not lend without that treatment plan being in place. So a seller, unfortunately, who hasn't previously dealt with Japanese knotweed, but instead leaves it to the point where they are selling their property, unfortunately then has very little choice but to bite the bullet and pay for the entirety of the treatment plan up front. Now, most specialist contractors will provide a 10-year insurance-backed guarantee for all types of eradication treatment. This policy can start either at the start of the treatment program or at the end of the treatment and monitoring period. And again, it will depend on the treatment company that you engage with. Now, while the insurance generally does cover the reoccurrence of knotweed, many policies will exclude any outbreak that arises if the occupier has treated the disturbed area. Now, I say some of those insurance policies will carry that exclusion, not all of them. So once again, as with so many things, if you're looking at taking on a treatment company to deal with Japanese knotweed on your property, alongside your investigation of their environmental capability, you also need to look at the terms and conditions of the insurance-backed guarantee to establish whether or not those terms and conditions limit your activity on the garden in a way that you would prefer not to see limited. If your plan is, once the treatment is done, to disturb the underlying soil, re-landscape, whatever it might be, make sure that the insurance policy you get doesn't prohibit that or cause the insurance to be null and void. Now, those of you that use the InfoTrack platform may well have seen that amongst the policies that are listed on it, it includes the CLS Japanese Knotweed insurance policy. Now, the policy provides a property buyer with up to £20,000 for a variety of losses associated with Japanese knotweed. And it's really an avenue that a property buyer may wish to undertake to protect themselves in the event that a seller has declared on the property information, the TA6 form, not known in relation to the Japanese knotweed question. Because obviously once they have declared not known, then subsequently, if knotweed is found to be on the property, whether it's been long established or whether it emerges at a later point, then it's the seller's responsibility or the new buyer's responsibility to deal with. Cover is available at a premium of £40 for residential properties and from £100 for commercial properties up to half an acre. Some of our policy covers, as I say, up to £20,000 and will cover buyers, lenders, landlords and successors in title as long as the policy is activated within 3 years of the inception date. It does have, within 5 years of the inception. It does have a 5-year term associated with it. It provides cover for costs and expenses solely and directly arising from compliance by the insured party with a remediation notice or completion of any required remediation works identified in the Japanese knotweed survey, or the cost of altering, repairing or demolishing any part of the property as a result of Japanese knotweed damage. And in addition, it will cover the cost of any settlement made out of court with the prior written consent of the insurer, including costs and expenses incurred by the insured party in order to ascertain potential liability for knotweed that has begun to creep onto a neighbouring property. The aim really here is to provide a degree of comfort for an incoming home buyer in the event they feel the property could have an exposure to Japanese knotweed. The seller has said they're not prepared to put their neck on the line and declare yes or no definitively. And the buyer doesn't want to be exposed potentially to those treatment costs and, were it to be relevant, potential loss of value at a point of later sale. So what then are the transactional points that you may wish to consider when dealing with your home buyers and sellers? Does the seller understand the implications of no and not known when they're answering the TA6 form? There have been a number of instances where a seller has quite casually put no in relation to is there Japanese knotweed on the property, without realizing they're taking a sort of an affirmative position. They're actually expressing a firm opinion against which they could be legally pursued if it turns out that knotweed is found on the property. From the buyer's perspective, do they understand that no, were it to be put in place by the seller, may be uninformed? It's all very well saying you have legal recourse against a seller in the event that they've answered no to the TA6 question and subsequently knotweed has been found. But not every buyer will wish to undertake legal action against a seller to then get a required treatment program in place. And equally, from a buyer's point of view, do they understand that the answer not known on the TA6 form exposes them? It makes them ultimately responsible for any knotweed that is found to be on the property. And I suppose really in relation to yourselves as conveyancers, are you advising your sellers and buyers about Japanese knotweed and the implications of no and not known? If it's any help, we do have some guidance text here which you can insert into your client care letters that advise a home buyer what the implications are of a not known answer when placed on the TA6 form by the seller. So we will include that, or rather InfoTrack will include this document in the slides and presentation recording they distribute not too long after the presentation. So if you think that's a useful document, do feel free to sort of customize and include within your buyer client letters. Perhaps another point to consider for those of you that have maybe a sort of cross firm responsibility, compliance responsibility within the firm, is really how as a law firm you may approach the issue. We've come across law firms whereby the treatment of the Japanese knotweed question in the TA6 form, the subsequent use of insurance, the form of text that goes into the client letters is left entirely to individual conveyancers. Equally, we've come across firms where there is a policy that provides a consistent approach across the entirety of the firm. And that may include common text in communicating the obligations and sort of context of the TA6 form, common text that is communicated to buyers that explain the implications of the answers given by the seller in the TA6 form, and common use and or recommendation of insurance. And if you are a regular user, or if your clients are regular users of the Japanese knotweed insurance policy, once again, how best can it be sourced? It can be sourced transactionally through InfoTrack on a case-by-case basis. Equally, InfoTrack are able to issue master policies associated with Japanese knotweed, derived from, of course, the CLS policy. If any of you represent firms where maybe there's only one or two of you on this, but you wish to have a sort of a firm-specific course on Japanese knotweed, we're only too happy to sort of collaborate alongside InfoTrack, come in and provide training in-house. So if you think that's useful, in-house might mean a visit, equally it could mean online. Of course, we're very happy to offer that sort of guidance. Now, at this point, Faye, I think if we've had any questions in, very happy to look at those. But I thought I might start with the questions that an InfoTrack client actually submitted prior to the course, and I'll just run through those, and then Faye, we can sweep up obviously any other questions that have come in.
Absolutely.
So, thanks, Faye. And so the questioner asked, first of all, how do you deal with Japanese knotweed that has not been treated and now the property needs to be sold? So I think this is being asked from the perspective of the seller. I think it is 99.9% certain that if the property is mortgaged, the incoming buyer's lender will require there to be a treatment program in place. And unfortunately, that treatment program, in all likelihood, would need to be paid for in full rather than taking advantage of the staged payment that the treatment companies typically offer. So my feeling would be that if knotweed is present on the property and it needs to be sold, unfortunately that knotweed is going to have to be treated. Otherwise the lender is likely to refuse to lend on it under current trading conditions. Whether lenders revise their behaviour at some point in the future as a result of the RICS change of guidance remains to be seen. Second question they asked is, can you get insurance if treatment has not been started and the property needs to be sold? So the answer to that can be yes, but it will come with a significant number of conditions. Firstly, that treatment is carried out according to certain industry standards. Secondly, that there is sight of that treatment plan prior to an insurance policy being put in place. But even then, and thirdly, it would depend on the degree of Japanese knotweed growth on the site. It's a very minor infestation. There is the potential for cover to be provided. But I have to be honest and say that if knotweed is present on the site, most of the time it is very unlikely that any insurance would be provided other than the insurance-backed guarantee that comes with the treatment company. Typically, insurers won't insure a burning building. Now, the third question is a really interesting one. If the knotweed is present in adjoining properties and the neighbouring is not cooperating to get knotweed treated on his or her property. Now, slightly depends on the context of the question. I'm not sure whether this question is being asked from the perspective of an incoming buyer or someone trying to sell their property when it's known that knotweed is present on the neighbouring site. Now, this is somewhat tricky because if it's within 3 meters, it's known to be within 3 meters, a lender may refuse to lend without a treatment program in place. And if the occupant of the neighbouring property is refusing to get a treatment program in place, it means it's likely that the property is going to struggle to be sold where a mortgage is involved. Now, this is where, unfortunately, you may have to start recourse for legal action. Ultimately, and we've mentioned MB estates earlier on in the presentation, ultimately it was only through application of ASBO legislation after several attempts to get voluntary remediation carried out that the knotweed was treated. So it would have been a criminal act for the MB estates to not treat that knotweed. So my suggestion would be is if you are minded to sell your property and you are aware of knotweed on the neighbouring property, unfortunately, you're going to need to get that dealt with, I would suggest, in the majority of cases, unless the knotweed is some distance from your sale property. Now, question number 4, really interesting one in relation to the surveying community. If there's a mortgage secured on the property, should the bank surveyor have picked up that there was knotweed present when the survey was done for the bank? And now there is actually a little bit of precedent for this, even prior to the revised guidance that is now out from the RICS. There was a case of Michelle Davies versus Connell's survey and valuation. The context of the case was that Michelle Davies bought a house and found there was knotweed on the adjoining land. The mortgage lender's surveyor did not see it and therefore did not consider its possible effect on the value of the property within the valuation report. Subsequently, when Michelle became aware of the neighbouring Japanese knotweed, she sued both Connell's and the adjoining landowner. Now, the judge ruled the case turned on whether or not the knotweed on adjacent land was directly visible from within the boundaries of the subject property or the accessible public areas which should have been noted and acted on. And the judge found that the surveyor, in confining their inspection to the garden of the subject property and what could be seen from the garden, acted within the appropriate parameters for a mortgage valuation inspection. So it was found essentially that the surveyor, in carrying out a reasonable level of investigation for knotweed both on the property and the surrounding area, could not then be found liable for the subsequent exposure of that Japanese knotweed and its perceived value on the property. And say this was a court case in 2019, and I think reflected the fact that valuation surveyors, there is only so much that they can do to establish if knotweed is proximate to the property. So in answer to the question, I think it's very much case by case. depending on whether the bank surveyor has deployed all of the tools that they are required to deploy, use of public areas, viewing of a neighbouring property, but without actually trespassing on it, to establish whether or not knotweed is present. In the court case, the judge did set out the context under which they would have recorded liability to the surveyor, but again, very much case by case, one would suspect. Now, the final question is really, what is the best way to move forward to deal with knotweed, whether or not the property is being sold? And my personal opinion, and I speak as someone who has had knotweed on a property previously, is frankly, there's no time like the present. If you have knotweed on your property, best thing to do, if you're able to sort of afford the treatment plan of say £3,000 to £5,000 over a 3-year period, is just to get it dealt with, because at some point it's likely to become problematic, either physically problematic where it to begin to spread, or it will become problematic at the point when you need to sell the property. And as I've mentioned previously, selling the property, at the point when you sell the property, you have to find that treatment cost in one lump, rather than being able to take advantage of the stage payments that companies tend to offer. So, Faye, have we had any other questions in?
Yes, thank you, Steve. I think that was a very informative webinar and particularly timely given the RICS update in February this year. I can see we've had a couple of questions come through, so I'll go straight to the first one. Are the risks to leasehold properties, such as flats in a block, much reduced from Japanese, generally speaking?
The physical risks, yes, because the knotweed is not going to physically impact on properties located further up, obviously. But where you have a potential exposure is if there is an infestation that needs to be treated, it may well be that under the terms of the lease agreement, all flat holders, all leaseholders within a freehold may have to make a contribution towards the cleanup cost. And of course, there is no obligation that the freeholder has to use the most economic form of treatment. If they go down the road of saying that, well, the treatment has to be done through excavation, it's extremely quick. Well, comparatively speaking, it's quick, it's effective, but it's significantly more expensive than using foliar spray or herbicide injection. And those costs may well then be split amongst all of the leaseholders on a site, irrespective of whether they're on the ground floor or the 5th floor. So I think it's still relevant for someone moving into flat, no matter how high up it is, to be cognizant of the impact of Japanese knotweed. It won't be physical, it could be financial.
Okay, lovely. The next question, and actually this is the last question, so if anybody does have any other questions, we are almost out of time, so get your questions in quickly and we'll do our best to answer them. But the next question is, does the question in the TA6 cover the property boundary only or the 3-metre rule?
It's the 3-metre rule. So the home seller is being asked to give an opinion as to whether there is knotweed present within their property and within 3 meters of their property boundary. Okay, so I think that's, again, that really plays into why the vast majority of home sellers would be, frankly, well advised to answer not known, because they simply don't have the knowledge of the plant in order to be sort of confident in any other way. I think whether or not they are answering not known probably comes down to the degree to which they understand the TA6 form and the guidance associated with the specific question on knotweed.
Okay, perfect. Thank you. So we haven't got any other questions, so I assume that you've carried out such an informative webinar, Steve, that you've answered everybody's questions during the course of the webinar anyway. So I'd like to say a big thank you to Steve for his time today, and I hope that everybody attending has found this session informative. If you do have any other questions about anything you've learned today, or questions in relation to ordering indemnities through the InfoTrack platform, you can contact your account manager who will be able to assist you. Alternatively, you can come straight through to InfoTrack directly.
Faye, can I sort of, apologies for jumping in here, Faye. I've just seen there has been a question posted by someone asking, let me see, I have a case where knotweed on an adjacent strip of land is unregistered. So to poster of that, and we do have your name, thank you for posting that. I'll pick that question up afterwards and come back to you, because there's quite specifics on the case there that I probably can't say in open forum. But when we do have an answer to that question, everyone, I will post both the question and the answer back through the guidance that the documents that InfoTrack distribute. But thank you for your question, and I will come back to you on that.
Okay, perfect. Well, I do think we're out of time now, so I would like to say thank you to you, Steve, for talking us through today's webinar.
Thank you.
Thank you to everybody for attending. So this session is being recorded, and we will send you a copy, as Steve's already mentioned, along with the slides and the document that Steve mentioned during the course of the webinar. So we will send that to everybody that's attended today, and thank you very much. All that's left to say is thank you for joining us and enjoy the rest of your day. Thank you very much.
Thanks, everyone.
Thank you.